heart for at least one teacher, my wife, who's taught in Mercer for 40 years. And I always say that the wrong actor showed up. One of these days she ought to come. And we'll talk a little bit about that. My name's Pete Acker. I live in Mercer. I practice in Hermitage. I'm also a special assistant district attorney in Mercer. I've been doing this for 40 years, believe it or not. I did not go to Grove City. I always joke that I wasn't smart enough to go to Grove City, even though I grew up in Sharon. But I was smart enough to marry somebody who went to Grove City. My wife went to Grove City, and I was smart enough that both of my kids went to Grove City. My sister went to Grove City, and she's a elementary school teacher in Olean, New York. And one of my brothers, who's a lawyer in Potter County, went to Grove City. My wife's brother went to Grove City. His wife went to Grove City. A couple of his kids went to Grove City. So I sued Grove City maybe a dozen times. I was involved in the ouster of one of the presidents. They still let me on campus. So I know Grove City well, and my mother-in-law and my brother-in-law and his family still live in Grove City. We're going to talk a little bit about legal issues in education. We'll have a 100-point multiple choice test at the end. I went to Denison University in Granville, Ohio. I then went to the Dickinson School of Law before the hostile takeover by Penn State. And I've practiced for 40 years. I'm back in my second tour of duty as a solicitor of the Mercer County Career Center, or the VOTEC. The first 17 years I was a partner in the biggest law firm between Pittsburgh and Erie. We represented most of the major school districts at one time or another. I've been special counsel to a number of school districts for employee discipline matters and also for student discipline matters. And we'll talk about it a little bit later, but in virtually every school district in the county, there has been an incident in which students had weapons, and at times significant weapons, in the school. So don't stick your head in the sand. That danger is out there, and be ready for it. I think my favorite weapon story is that a second grader was in the cafeteria and had brought a little item in his book bag to school and was passing it under the table to his various schoolmates. It was a loaded .25 caliber revolver, and the safety was not on. And they were passing around under the table, so one brush of the trigger with enough force and it would have gone off. But we've seen everything from knives, switchblades, guns, nunchucks, throwing stars, things like that. So you need to be alert to weapons. They're a real risk. And every year I basically try to come in and say, boy, it's been a good year. There hasn't been anybody murdered in a school in the past year, but that's generally not true, and we'll talk about that. I've been doing this for a long time now, and I was given a handout that I was supposed to cover, and then we'll ignore it and talk about what we want to talk about. I should tell you that my one roommate in law school told me I was nothing if not opinionated. You'll figure that one out in a hurry. And clearly, the views that I express are not the views of Grove City College, the professors, or anybody else. The first legal concept I want to talk about is loco parentis, in place of the parents. For 15 years I said, don't worry about it, we're not going to talk about it, it's basically irrelevant. Then there was a flurry for a couple of years where there were a couple loco parentis cases, and now it's kind of faded again. It means in place of the parents. So historically, the teacher of the school has been able to step into the shoes of the parents for certain issues under certain circumstances, but it's limited. Now virtually every school has their students fill out a form, or their parents or guardian fill out a form which says, these are the parents or the grandparents, these are the contact people, this is the health insurance, these are the phone numbers to get a hold of us. If you can't get a hold of us, get a hold of Aunt Susie, and this is her contact information. This is the hospital we want our child to go to, and this is the family doctor. So now when there's a medical issue, and that's usually how loco parentis comes up, the office pulls the card and off they go. So basically, loco parentis permits the teacher of the school to step in the shoes of the parents to make decisions that have to be made then and there. So if the child has to go, or the student has to go to the hospital, you can tell the school, look, it's got to go to the hospital. You can make that decision. When they get to the hospital and they stabilize that student so that they're not in imminent danger, and they go, they need a lung transplant, loco parentis does not say that you can do non-emergency, non-essential medical decisions. Only immediate medical things. So you get to the hospital, and probably the teacher isn't going to the hospital because you have your other students, usually it's an administrator and a school nurse. You can sign admission forms. You can authorize certain medical procedures. You know, we need to scope this kid down the throat to see what they swallowed. That kind of thing clearly falls within loco parentis. Freedom of speech and freedom of expression. First Amendment to the Constitution, freedom of speech is one of the most important amendments out there. Freedom of speech in the school is not unlimited. It's not unlimited in life. So you go into a crowded movie theater and you say, fire. That's a First Amendment expression, but it's not protected because you can't have everybody doing that. Obscene speech is not protected. Speech which is disruptive is not protected. So no student has the right to disrupt your class. And the school has the authority to try to limit those types of expressions so that they're channeled into a more orderly, controlled manner and aren't disruptive. The big issue always deals with school publications. If it's a school publication, the school has the right to censor that publication, and that's always been a battle. It's been a battle for decades, and I think it will in the future. But if the school sponsors the publication, the school's providing a faculty advisor, if the school's paying for it, they can censor. But you don't want to suppress freedom of speech or freedom of expression unless it's necessary to keep the order in the school. Freedom of conscience often comes down to separation of church and state. And people have the right to express their views, but again, it falls under the First Amendment. You don't have the right to be disruptive about it. And teachers do not have the right to advocate religion or to wear religious emblems. I know it's violated all the time. There's a statute in Pennsylvania that specifically says it's improper to wear religious emblems, crosses, Star of David, those kinds of things. It happens all the time, and just remember there is a statute that says that you shouldn't do that. Back in about 1962 or when I was in law school, my professor said, you'll figure this out one day, but some days the law is just an ass. And because it doesn't make any sense and the decision's off the wall. In 1962 or 1963, the atheist Madalyn Murray O'Hair won a U.S. Supreme Court decision about school prayer. And it basically said that you could not have school prayer, church or school-sponsored prayer in school, which is why they went to silent minutes of contemplation or meditation. It's violated every day in many schools in America. But you want to be careful about it because everybody and their grandmother either is related to a lawyer or has one living next door or is an uncle or whatever, so there's no shortage of lawyers out there who like to prove what jackasses they can be. And the ACLU's out there, and so there have been many, many instances of school-sponsored prayer that have ended up in litigation. And the results of that litigation are always basically the same in a public school is that you can't have it. Prayers at sporting events. Baccalaureate, they generally moved off of the school premises to a voluntary private service that everybody and their grandmother goes to, usually. But they can't hold those generally in schools anymore. Dress and appearance. Yes, they can impose dress codes. There've been a lot of litigation about dress code. There've been discussions about uniforms. Everybody has their theory on it, but they do have the right to do that. One of my favorite topics is due process of law. It comes from the 14th Amendment to the U.S. Constitution. There's a state constitutional provision as well. I like to tell a story about due process. There's two types of due process: procedural due process and substantive due process. So procedural due process in a student context is, we're going to advise you of the charges against you. We're going to tell you what the evidence is against you. You'll have a hearing before the school board, and a decision will be made. So the joke was in the Wild West, when they caught the cattle rustler, they'd say, okay, these are the charges, you're going to have a hearing. You can have a lawyer. You know, they didn't have lawyers in the Old West paid for it to defend people. So that was the procedural due process. You have a right to confront and cross-examine your accusers and the witnesses. You can bring your own witnesses. That was procedural due process. Now, that worked pretty well. And then the sheriff or the judge would say to the cattle rustler, and after you get your fair trial, we're going to take you out back and hang you. That's not substantive due process. Substantive due process is fundamental fairness. So if the result of your trial is preordained, you're going to be found guilty. And if the punishment is predetermined, we're going to take you out back and hang you, you're not getting any substantive due process. So you have to remember that due process is more than just the procedural process. It's also the substantive process, which is fundamental fairness. So I'm a big believer that, and even as a prosecutor, you investigate, you develop the facts, but ultimately the facts are what the facts are. And the facts, when properly judged and fairly judged, will lead to the appropriate result. When somebody tries to manipulate the facts, that's when substantive due process gets lost. Gender discrimination. You can't discriminate on the basis of gender. We have Title IX. Slippery Rock was an excellent situation. They got sued over it. So what's it mean? I don't know. If I had 20 male sports and 10 female sports, is that in violation of Title IX? Yes. What's the fix? I can increase the number of women's sports to 20. I can decrease the number of male sports to 10. We can have 15 on each side. Or arguably, we can have gender-neutral sports, which really isn't terribly fair. And that really has not been tried except theoretically. So you need to be alert to Title IX. And the U.S. Justice Department Civil Rights Division is out there. They're looking for it. It gets reported. The ACLU's out there. If there's Title IX gender discrimination out there, they will come flying. So don't mess with it. Fourth Amendment to the Federal Constitution, search and seizures. Where does that generally come up? Lockers, backpacks, purses, pockets. Not all searches and seizures are unreasonable, and that's what the Fourth Amendment goes to, is unreasonable searches and seizures. So, does the school have the right to go, eeny, meeny, miny, mo, that locker right there? I'm going to search that locker. I don't have any suspicion about that locker. I just like that locker. I want to search that locker. That's not permitted. If you get a tip and it's from a reliable source, you don't have to have probable cause, you only have to have a reasonable suspicion, then you can search that locker. You can bring in the drug sniffing dogs, which they often do right before breaks or over breaks, and you can run the drug sniffing dog up and down the hallways past every locker. And I don't know if you're familiar with drug sniffing dogs. They're generally very well trained and very effective. Not perfect, but very effective. So the dog, normally when he hits on a locker, sits down. He'll sit down right in front of where it's receiving the set. In that situation, the school has the right, or the police, to search not only the locker in front of the dog, but one on either side of it. Okay, that's a reasonable search. However, and I argued this for at least 15 years, you're a teacher, you're not a police officer. And so every school has a book of a student handbook which says, thou shalt not A, B, C, and D. You can't have drugs, you can't have aspirin, you can't have ibuprofen, you can't have cigarettes, you can't have drugs, you can't have alcohol, all those things. So if you're a teacher and you're looking for those things, you're acting as an employee of the school district. But the problem is a lot of those student handbooks say, and if we find it, we will call the police and we will have you prosecuted to the full extent of the law. So I harped for 15 years that if you're acting as the agent of the police, you're held to the same standard as the police, which isn't a reasonable suspicion, it's probable cause. And in many situations, if the police want to search a locker, they probably ought to have a warrant to search the locker. And in order to get a warrant, you have to have probable cause from a reasonable source that there's likely something in the locker. And therefore, about 3 or 4 years ago, there was an appellate court case which said exactly that. If you're acting as a police officer in your role as a teacher or an administrator, and you do that, you're held to a higher standard. And even if you could have done that as a teacher, if you're acting as a pseudo police officer, your search, which would be valid as a teacher, is going to be knocked out if you're acting as an agent of the police. My view is, if you're a teacher, you're looking for violations of the school handbook. If there's a violation of the school handbook, you call the administrator, they come look at the evidence, and they handle it from there. If they call the cops, fine, but it's not your job to call the cops. What the school does with it is the school's deal, but you're not agents of the police. There's a provision that the feds passed when I was a freshman in college 500 years ago, which said that students 18 and older had privacy rights. 17 and under did not. Their parents had rights. So I went to college. I was 17. I turned 18 between semesters. My father calls me up in February and says, I didn't get your report card for the first semester of your freshman year. I go, I don't know why not. So I go and I talk to the registrar. And he goes, well, you turned 18 during that period. Under this new federal law, without your signed consent, we're not permitted to disclose that to your parents because you're 18. You have a right, once you're 18, you have a right to privacy. So in high school, especially juniors and seniors, you will have students that turn 18. So what the law is, if they're 18, you can't talk to the parents or disclose things to the parents without the consent of the 18-year-old student. If they're under 18, you can. Haven't seen a lot of action on that, but that's the law. Conditions of employment. You have to have a valid teacher's license. Now you've got continuing education, which lawyers have had for a long time. If your certificate isn't up to date or you don't have an emergency certificate and you let your certification lapse, they can and will terminate you. Because the Department of Education comes in every once in a while and goes, let me see the certificates on all of your instructors. And if your certificate is not currently valid, they're going to want the money that the school district paid for you teaching your students reimbursed to the state. So you must keep your certificate in place. You know, when my wife started teaching in 1975, her certificate said 99 years. You know, initially it was a temporary certificate, 2 or 3 years, and then you get your permanent certificate, and it was 99 years. Well, something happened in that 99 years during the interim. Her certificate still says 99 years, but now they put all these additional continuing education. So keep on top of that. Most school districts have collective bargaining agreements, usually with representatives of the NEA or the PSEA. Those are controlling. So you need to know what that is. Teachers can be dismissed. There's specific limited reasons, and then they have collective bargaining agreements which say you have to be fired for just cause. It's very hard to get fired as a teacher except for catastrophic issues. What are some of the catastrophic issues? Well, there's case law that said 3 DUIs and 2 driving under suspension was immorality and you could get fired for it. Well, what's immorality? It's what 5 out of 9 school board members say it is at any given time. Way back when I was in school, women who were single and living with somebody, they were subject to getting fired under immorality. The guy wasn't, but that was the inequality in society. Then it was if you were married and you were having an affair, even if it wasn't in the school, that was immorality and they could fire you. And usually it was the single teacher who got pregnant and they got fired. The father, nothing happened to him. So hopefully we've gone past that. But that's one of them. Insubordination is another one. So if your supervisor tells you to do something, you better do it. There's due process in dismissal. You're allowed a hearing in front of the school board, but usually the rubber stamps because the administrators, tell the board what to do, and usually they do it. So most of the time it goes to through the union grievance process, which is usually a 4-step grievance. AIDS testing, it's a form of search, and they can't require them unless there's a specific reason for them. Drug abuse testing, they can do, but most collective bargaining agreements preclude that, and usually they only do drug testing on new hires. Student drug testing we can talk about. There's a Pennsylvania Supreme Court case which says you can do it under certain circumstances. It's still, if you have a reasonable suspicion that Johnny's high, the school administration can require that Johnny submit to a drug test. The case law says if you're involved in extracurricular activities, sports, choir, orchestra, band, glee club, 4-H, cheerleading, and my all-time favorite, parking pass. That's okay, and they can require students who get parking passes to be drug tested. That hasn't been very common, and the reason for that is one-shot drug tests have questionable accuracy, and parents take it very seriously when Johnny's getting chucked out of school. Johnny's parents have lawyers, and the school is really not looking for that hassle. I spent 20 years as a solicitor for the Mercer County Behavioral Health Commission, which does intellectual and developmental disabilities, mental health, and drug and alcohol. And the focus now on students is to try to get them help to address their addictions or their issues. And it's very important that that happens. And I'll give you a tip. We have the director of the Behavioral Health Commission has been there about 3 years. She's from Erie. She's under 26 years of recovery from alcoholism. And the success rate of drug and alcohol programs is 20 to 25% on a one-shot deal. Usually it takes multiple attempts to take. So I said to her one day, these rehab programs don't really seem to be working very well. So why are you 26 years into your recovery? She goes, you didn't see me 26 years ago. It was ugly. and I'm not proud of myself, and I slammed the floor multiple times before I got on track. Now when they say it's one day at a time, it's one day at a time. And you have to keep working on it. And she goes, the other issue, and I think this is very important because we see it all the time in the district attorney's office. I never made any progress to my recovery until my undiagnosed and untreated anxiety disorder was addressed and treated. And her view is that anxiety is a very common factor in the addictive personality. So if you see people that are suffering a lot of anxiety, students that are suffering a lot of anxiety, and they appear to have a drug or alcohol problem, they probably need to address their anxiety, and that's a tip that you can give them, or their parents if they're under 18. And our other pitch is we just can't do this with methadone and Suboxone and Antabuse. Now there's Vivitrol, which works very well on alcohol and to some extent on opioids. They need a 12-step program, and they need counseling. So these are issues. Well, we don't have those issues in school. Yeah, you have them in every school. Some schools just close their eyes to them. This is an opportunity for you to steer the life of young individuals before they totally screw up their lives. So my wife now, I'll give you another tip. If you go off on maternity leave, come back. Because my wife spent 9 years as a teacher. She retired to motherhood. So she was going on step 10, and she had a master's degree. They were never going to hire her back as a full-time teacher. So take your maternity leave and go back. Don't give up your job. And so she says to me, we have these kids, they don't do anything. What's going to become of them? And I said, your son and I are going to prosecute him. And it's amazing, we see every day the students that came out of Mercer High School, some of which my wife had, that come out of other schools. When you see the kid that doesn't fit in, that drops out of school, he just never fits in, he or she doesn't fit in, what's going to happen to them? Well, in significant percentage of them are going to end up in trouble with the law, especially if they have drug and alcohol program. So part of your deal, and I say this every time I come here, is you have to help guide these students to a productive life. You can't sit at home playing on your cell phone or Game Boys or whatever till 3 o'clock in the morning and struggle out of bed to wander into school or put your head down. That's just not acceptable behavior, and it's not good for the long term. Child abuse. One of the things I've been doing a lot of over the last 2 years as a special volunteer ADA is child abuse and sexual abuse. It's rampant. And we are merciless. 31-year-old mother, 11-year-old, 8-year-old, 6-year-old, sexually abusing, sexually molesting her 2 oldest daughters, and letting her non-live-in screw buddy, who was living with his fiancée, into the house, and he sexually molests the 2 older ones. And the way that it came to light was they told the second daughter, who was 8 at the time, if you don't submit, we're going after the 6-year-old. Okay, this is life out there. That happened in Sharpsville. Okay, that's life out there. You have to be alert to how sick and twisted society is. And that was reported. And the mother, I launched her to 35 to 70 years in the state penitentiary. And the boyfriend, who had a bunch of other issues and is dying, he's doing 18 to 40 in the state penitentiary, which is a death sentence for him. The ramifications of sexual abuse and physical abuse and emotional abuse on children is catastrophic. You have to identify it, you have to recognize it, you have to report it. If you don't report it, you can be fired and you can be prosecuted. You must report it. Johnny doesn't fall down the steps every week. Johnny didn't have black and blue marks because he was playing football or he fell off his ATV. Report it, please. Tort liability, can you get sued? Yes, you can get sued. This is a suit-happy country. Use your common sense, use your judgment. I'll give you a couple examples. Cell phones, a blessing and a curse, and probably the worst enforced rule in schools. Teacher gets a report that 17-year-old girl has sexually explicit photos on her phone, which she had shared with her 18-year-old boyfriend, and the possession of them by the 18-year-old boyfriend is a federal crime. So the teacher seizes the phone and powers it up and scrolls through the photos and sees these sexually explicit photos of the 17-year-old. The parents of the 17-year-old sue the teacher and the school and get $33,000. So when we do drug raids, for example, we do them, 3 or 4 or 5 times a month. When we do drug raids, drug dealers always have phones, usually 3 or 4 or 5 phones. So what we do when we go out and do these raids, when we get the warrants, we want the warrants to include the scales, the drugs, the packaging, and the cell phones. So we gather up the cell phones, put them in an evidence bag, and then we go and get another warrant to open up and download the contents of these cell phones, because we want the text messages as to the drug deals and the photos and all that other stuff. So we go get a second warrant for the cell phones, and then the state police and some of the local police department, bigger local police departments, they dump the phones for us. But once you seize the phones, they're preserved. So if you're having a problem with a cell phone, let the school get the phone. Then they can decide they want to give it to the police. Let the police get a warrant to look at the phone. Let the police dump the phone. But don't you look into a student's phone. Don't do it. I mean, it's okay if you're not allowed to have a phone. Give me your phone, put it on the desk, send it down to the office. They don't even do that in most places. But don't power them up. Don't scroll through them. Don't, well, I know you were texting. Let me check. No, don't do that. That's probably an illegal search and seizure, and you can get sued for it. When we talk about searches and seizures, one school suspected that a student had an over-the-counter ibuprofen or 2. I mean, that's a terrible drug if you know. Right up there with heroin, Over-the-counter IV-800 or whatever it is. So they take this girl down to the nurse's office, and they pat down, they dump out her purse, they empty out her pockets. They strip search her, and they do a body cavity search on her. There's a saying I learned a long time ago. Bad facts make bad lawsuits. Well, that's a terrible lawsuit. It's an over-the-counter analgesic, for God's sake. Let it be. I mean, there's no evidence she was selling them. I mean, you don't have to sell them. You can walk into any convenience store in town and buy ibuprofen. That's what they did. Yes?
And I just want them to know that this case is in our textbook this semester.
Okay.
Yeah. It's coming.